Hello, welcome to A Taste of Justice with Professor Angela Mae Kupenda. I'm a professor at Mississippi College School of Law, but I give my school name only for identification purposes. Views and interpretations expressed here are not necessarily those of my school, but are my own. Now, I hope you go back and you watch the introductory video, and after that, we went straight into constitutional law. As you know, we're going to have a series that would include materials from my constitutional law class and also from my civil rights lawsuits class that I'm teaching this semester. These videos are designed for all of us to get a taste of justice, to have more learning and enlightenment, but it's also designed for my students. We're having classes remote to supplement the hard work they're doing on their own and they would do with me in the classroom. Now, we've been talking about state action, and the general rule is that there must be state action. State action refers to governmental action. It does not necessarily mean just the state of Alabama, the state of Mississippi. It can be a city, a municipality, the officers. It can be the federal government. And I want to clear up one point. When I listen to the last video, I was referring to there are different ways to find that the government is involved. And one way the court said, even if there is extensive funding, that is not enough to say state action. I referred you to the Rendell Baker case, and then I misspoke one word. In Rendell Baker, the court said that even if there is extensive funding coming from the federal government or from the government, that does not turn a private school into the state. That's the explanation I intended. Now, I want you to excuse my arms. I took my jacket off. I had to get comfortable because I told you we're about to go deep. We're about to go back to the deep South in the late 1800s. And you know, whenever we go deep, that undoubtedly we're going to have a discussion on race. Race in America, race in the deep South. So we've been talking about state action. And I intentionally introduced you to the principles before I told you about the case, where some of those principles come from, where they originated. I saved that case for us to go deep at this point, after I've built a bit of a relationship with you. Now, we know about slavery. After the Civil War, Emancipation Proclamation, the end of slavery. Then we had amendments added to the Constitution. They are called the Reconstruction Amendments. The 13th Amendment says no more slavery, no more private slavery, no more state-sanctioned slavery. The 14th Amendment listed a number of things states should not do. And the 15th Amendment, I know you're saying the right to vote for Black people. Well, you're partially correct. The right to vote for Black men. Black women did not receive the right to vote until white women also received the right to vote in 1920. We'll talk about that more later. Now, these amendments have an interesting feature. They have the Reconstruction Amendments, and you can pull them up on Google. Look, I'm going so fast. My last video was 20 minutes. That's too long. We've got to get this thing under 12 minutes, but let me slow down. Now, the Reconstruction Amendments have what are called enabling provisions. They say that Congress may pass appropriate legislation to enable the purposes of the amendment. You see, The federal government has three branches, right? Co-equal branches: Congress, the Office of President, and the federal courts. They are called co-equals, not one more superior than the other, although in different instances, one may have more power than the other as defined by the Constitution. Now, Congress has what are called enumerated powers. The Constitution says that Congress has the powers herein granted. They're numbered out, so to speak. We'll talk about that more later. But generally, Congress has to show that it has the power, or legislation it passes may be challenged as being unconstitutional. So at the end of slavery, some of the states just were not having a racial equality. There were Black codes, there were laws, there were the growth of the KKK, all kinds of things to maintain the South the way it had been. So Congress passed a law, and the law said, look, these people were slaves, now they're free. They should have the right, if they have the funds, to dine in most restaurants open to the public, to ride on the first class in the railway if they have the money, and other things like that. And if a private business does not grant them this right, they will be fined. So you know what happened. Some private businesses said, you're not sitting in first class. You may pay that amount, but you're not gonna sit up there. And so you're not gonna stay in this lodging house. You're not going to dine in this publicly open restaurant because you're Black. And so then there was a lawsuit. So this is called the Civil Rights, RIGHTS, sometimes I mess up on that T, as cases from 1883. I have the name at the bottom in the text if you want to Google it and learn more. Yes, learn more. So here, the question in the case was, did Congress have power in order to tell private businesses that they had to treat Blacks equally? The argument was they did, because there's the 13th Amendment, there's the 14th Amendment, and both have enabling provisions that says Congress can pass appropriate legislation to help Black people be free from slavery, and so that their rights of equality will not be denied, so to speak. Well, what do you think the court said? There was a 8-1 opinion. 8 justices said, Congress, you can't do this. It is outside of your constitutional power. They said, first of all, private racial discrimination, this is what the court said, private racial discrimination in 1880 something, they said it's not about slavery. They said it's not about slavery at all. Slavery is about holding a person. They're free, they're just not free to dine in these places. Then the argument was, well, what about the enabling provision? The court said, well, the 13th Amendment reaches actual slavery, but it also reaches the badges, BADGES, and incidents, INCIDENTS, of slavery. And the court said that private racial discrimination in 1880 was not a badge and incident of slavery. And the court said, it's time for Black people to stop being the favorites of the law and to stand on their own 2 feet. And this is not about slavery. But then the other argument was, what about the 14th Amendment? The 14th Amendment says that these former slaves should have equal protection under the laws. Well, the court said, read the 14th Amendment. And I want you to take a look at it too. You can Google it later. Read the 14th Amendment. The court said, it says no state. And this is not the state. These are private businesses that don't want them to come inside. So there is no state action for them for no constitutional rights at issue under the Equal Protection Clause. Therefore, Congress should not have acted. Now, there was one dissent. The first Justice John Harlan. Now, I say the first because John Harlan later had a grandson who also was a justice on the Supreme Court. His grandson didn't quite have his same viewpoint. Now, John Harlan dissented. The opinion is 8. We're going to continue segregation in these places. Congress can't do anything about it. To 1. John Harlan just stood by himself and wrote this very powerful dissent. It was on the losing side, but he wrote it. He said, now hold up. You're saying this is not about slavery? Then what is it? Racial discrimination is a continuation of the themes from slavery. And then he said, what is private racial discrimination if it is not a badge, an incident coming from slavery? Then he said, all of this time, when private people wanted to hold on to their slaves, this court protected the property rights of slaveholders. But now that we have these individuals seeking to be free and equal, this court turns its back. Now, I got to tell you something about John Harlan. John Harlan was a white man who was a Supreme Court justice from a very wealthy family. John Harlan's family had owned slaves. Now, this is the dissenter now who is on the side of upholding this legislation and ending racial segregation. John Harlan's father had owned slaves, and John Harlan himself had owned slaves. As a matter of fact, when they were adding the Reconstruction Amendments, John Harlan initially was opposed to them. His view changed. Now, some people said, what's up with you, Justice John Harlan? You are inconsistent. At one point, you're not on the side of the slaveholders, you own slaves yourself. On the next point, you're fighting for the rights of these former slaves. You are inconsistent. And John Harlan said, I would rather be inconsistent and right than to be consistent and wrong. Did you get that? You should read about him. There's some excellent readings about him. Maybe his obituary in the New York Times talks about him. He was called the Great Dissenter. It makes you wonder about the value of dissent. Now, how did John Harlan get to this point? Oh, I got some more for you. John Harlan had a brother who was Black. Now, you may be a little confused here. How did John Harlan get a Black brother? Well, first of all, let's just say the historians say he had a Black brother. And his Black brother was a slave for many years of his life until his brother bought his freedom from his father. Now, how did John Harlan get a Black brother? John Harlan's father was married to John's mother, and they had John. John Harlan's father also had a child, also impregnated a slave. And they had a son named Robert Harlan. And like I said, Robert Harlan, he was educated. He was a slave, but they allowed him to be educated. You know, many slaves could not be under state law and just period. The masters maybe didn't approve of them. Check out Frederick Douglass' narrative and you'll read about why. And so because Robert Harlan's mother was a slave, that made him Black and a slave. You know, the drop of Black blood, and also his status followed the status of his mother, and that's how slavery was, one way it was able to continue. Otherwise, if Robert's status had followed that of his father, he would have been free like his brother John. So I wonder if John Harlan, Justice Harlan, became inconsistent and became in favor of more racial equality as he observed the struggles of his brother or his half-brother, because there were struggles, even though the historians say he worked very hard. And one even said he used to lend money to some of his white brothers. Now, John Harlan's dissent was one vote. So as a result of this opinion, segregation in the South continued. The Jim Crow South, separate and unequal, and all of this, the civil rights movement. And you may say, well, how did this change? The court said Congress didn't have power. How did Congress get power later? Oh, it is fascinating. We're going to get to that in a later video. But let me just say this. The majority said if this was about money, if this was about commerce, then maybe Congress had the power. And the way we end up getting these laws upheld against private racial discrimination was pursuant to Congress's power under the Commerce Clause. But that didn't come until much later. If you want some great reading, some interesting reading, check out The Green Book. I know you've seen it in a movie, but it was for real. There was a Green Book that would tell African Americans who were on the road where they could stop. And sometimes it may have been at someone's house where they could stop and get a sandwich or spend the night because places denied them access. Well, anyway, I want to make this last point. How can 8 justices come to such a different view than this one? And it has to do with how they interpret the Constitution, perhaps. It may have to do with some other things. You know, John did have a brother who's Black, but it has to do with whether or not they're interpreting it in a very strict type of sense, or as Justice John Harlan, the first Justice John Harlan said, look at the spirit of the Constitution. You got to look at the spirit of the Reconstruction Amendments. And then they would see, according to John Harlan, that Congress did have the authority and it was the right thing to do. I mean, that's the story. We're going to talk about this some more throughout the semester. At this point, I want to just thank you. We have completed the state action videos with this clip. Thank you for your patience as I rushed through and as I had to get comfortable to talk about this topic. And also, I'm going to do some clips for my civil rights lawsuits, Section 1983, and that's interesting, dealing with police immunity. It will be on this same channel. Hopefully I'll do those in the next couple of days after I reread the materials, right? Okay, so thank you. Subscribe, sign up for notifications. Remember, Our goal here is to have a little, just a taste of justice by learning a little bit more about the law and thinking about these principles so that we, the people, can form a more perfect union and establish justice in our land. Thank you so much. A Taste of Justice with Professor Angela Mae Kupenda. See you soon. Bye.